Here's a case that turns on a small but important twist in the way we protect our waterways. In City and County of San Francisco v. Environmental Protection Agency, the Supreme Court took up the question of whether the EPA can issue pollution permits that simply say, "Make sure the river stays clean," without spelling out exactly what steps a company must take. The court said no. Under the Clean Water Act, the EPA has to give clear, step-by-step limits on how much of a pollutant can go into the water. It can't leave a business guessing or hold it liable only when water quality slips. Nine Robes uses nonpartisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. In 2019, EPA renewed San Francisco's NPDES permit for its Oceanside Combined Sewer Overflow Facility and for the first time included two receiving water limitations. One provision barred any discharge that contribute to a violation of any applicable water quality standard, and the other prohibited discharges that create pollution, contamination, or nuisance under California law. San Francisco petitioned for review in the Ninth Circuit, arguing that Clean Water Act does not authorize these end result requirements, conditions that hold permittees liable for the quality of the receiving waters, rather than prescribing specific practices or numeric effluent limits. The Ninth Circuit upheld EPA, construing the legal authorization of any more stringent limitation necessary to meet or implement any applicable water quality standard to encompass end result provisions. The Supreme Court granted certiorari to decide whether EPA may condition permit compliance on receiving water quality. Justice Alito delivered a unanimous opinion reversing the Ninth Circuit. The court held that current law does not authorize end result requirements in NPDES permits. Its analysis rested on three pillars. 1. Text and structure. Subsections A and B of Section 1311b1 refer expressly to effluent limitations, which are numeric or definitional caps on discharges, whereas subsection C authorizes only any more stringent limitation that is necessary to meet or required to implement water quality standards. The ordinary meaning of limitation and the verbs meet and implement point to specific, externally imposed restrictions on quantities, practices, or methods, not open-ended liability for end results. 2. Statutory history. Congress deliberately abandoned the pre-1972 enforcement model, suing polluters after water bodies failed to meet quality standards in favor of a forward-looking permit regime. Allowing EPA to reintroduce abatement-style, receiving water requirements would contravene that design. 3. Permitting scheme. End result provisions undermine the CWA's permit shield, which protects permittees who adhere to all permit terms, and they offer no mechanism for allocating responsibility when multiple dischargers contribute to a water quality violation. EPA has ample alternative tools including numeric and narrative effluent limitations, best management practices, information gathering authority, and emergency powers to safeguard water quality. Accordingly, the court reversed and remanded. Justice Barrett filed a partial dissent, joined by Justices Sotomayor, Kagan, and Jackson. While she agreed with the majority that EPA laws are not confined to numeric effluent limitations, she disputed the court's restrictive interpretation of what counts as a limitation. Barrett argued that prohibitions on discharges that violate water quality standards are limitations in ordinary and statutory usage. She maintained that any concerns about vagueness or multiple polluters can be addressed through arbitrary and capricious review or by EPA crafting clearer permit terms, and she would have affirmed the Ninth Circuit's broader reading of the law in question. The CWA's NPDES program rests on carefully calibrated statutory language. Section 13111b1 draws a distinction between technology-based effluent limitations, which cap pollutant quantities, rates, or concentrations, and the broader authority in C to impose any more stringent limitation needed to meet or implement state or federal water quality standards. By omitting the word effluent before limitation in C, Congress signaled that EPA may employ non-numeric measures, best management practices, narrative restrictions, or other operational controls to achieve water quality goals. At the same time, the 1972 amendments discarded the WPCA's retrospective abatement actions in favor of a proactive permit regime and enshrined a permit shield to insulate compliant permittees from liability. This dual structure empowers EPA to balance uniform technology floors with site-specific water quality objectives, requiring clear, enforceable permit terms while respecting state standards. Where ambiguity or attribution issues arise, such as multiple dischargers, EPA and the courts can resolve them through regulatory guidance or judicial review under the Administrative Procedure Act. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.